The question is that this House do now adjourn. Dr Neil Shastri-Hurst.
Thank you very much, Madam Deputy Speaker, and I'm grateful to have been granted this adjournment debate. It is a sad reality of life that marriages fail. This can be for a variety of reasons, and I don't seek to provide a critique upon the underlying causes in today's debate. However, one of those tragic consequences of divorce is the disruption and pain it causes to children. Evidently, an amicable relationship between parents would enable arrangements in respect of where a child resides following a divorce to be made without the intervention of the courts. This avoids much additional heartache and the adversarial nature that flows from contested hearings, Madam Deputy Speaker. However, such contested hearings cannot always be avoided in each and every case. And whilst it may be the intention of the system to protect the privacy of individuals and families, during the course of these hearings, the reality is an increasingly inefficient and at times unresponsive system which fails to place the emotional and psychological needs of the parties at its centre. The flaws in the present system, Madam Deputy Speaker, are regrettably clear for all to see. By failing to address them, parties are left with a system that undermines the very values it seeks to uphold. Values of fairness, natural justice and the well-being of children at its core. Now, Madam Deputy Speaker, this is such a vast topic that it would be inconceivable to address all of the issues in the course of this adjournment debate. And for that reason, I wish to focus upon the constitution of the bench who hear child arrangement order cases. And the reason for this, Madam Deputy Speaker, is simple. The anchor point in all family law cases involving a child should always be that child's best interests. To create an outcome that supports and promotes a child's safety, emotional and psychological well-being and protects their future prospects. In some way, shape or form, it is almost inevitable that each and every member of this House will have had some experience of child arrangement orders, whether that's through constituency casework, personal experience, or through family and friends. Such cases are sadly far from rare. And if you'll indulge me for a moment, Madam Deputy Speaker, let me tell you the story of one such case. And I suspect this is a story that will resonate with many up and down the country, because it is sadly an all too familiar experience. A young child who, by virtue of their age, cannot fully articulate their wants or desires, whose loyalty is split in two, who does not want to be seen to betray either parent, who is already dealing with their world being turned upside down, whose future is decided in a sterile magistrate's court, often as a mere timetabling exercise. They now face birthdays, Christmas, Easter, all split in half. Weeks are cut in two. Weekends alternating between one household and another. Leaving that child with no sense of oikophilia, no love of home. A child who feels different from their classmates because they're forced to go to school with their overnight bag. A child who constantly lives with the anxiety of turning up to school without their sports kit because they fear it's in the other parent's house. A child who feels nomadic, often confused and invariably distressed. The scale of this problem, Madam Deputy Speaker, can be seen starkly in the context of Kafka's own figures as of the 31st of August of last year. 16,671 open private law children's cases involving 25,670 children. In the first quarter of 2024, the average time for such cases to reach a final order was some 44 weeks. And during this period, children are left with uncertainty. Now, the magistrates have formed an integral element of the England and Wales legal system since the 12th century and the reign of Richard I, who appointed the first keepers of the peace. Almost 200 years later, pursuant to the Justice of Peace Act 1361, the term Justice of the Peace was formally introduced. So I don't propose, therefore, to the reform of the role of the magistrates' courts lightly. However, I have reached the view that there is an overwhelming policy argument for doing so. Now, Madam Deputy Speaker, I am not for one moment suggesting that magistrates do not have an important role to play in the justice system. Self-evidently, that would be a fallacy. However, I'm increasingly convinced that the nature and focus of their work should be reconsidered. And in the case of child arrangement orders, it is my overwhelming view that the Magistrates' Court should no longer play a role. The reason for mounting this argument, Madam Deputy Speaker, is simple. There is an inequality in our legal system when it comes to private law family cases. Cases which decide the nature and degree of contact a child has with each parent. Cases which determine the long-term future of a child. Cases which by their very nature have a significant and lasting impact upon any child. Presently in this country, Madam Deputy Speaker, private law children's cases can be heard before a bench of 3 magistrates or a district judge with a family ticket. Magistrates are a lay bench who, well-meaning as they may be, are not required to hold any formal legal qualification. And whilst magistrates undergo some specific training following their appointment, this is not more than a handful of days per year. Compare and contrast, of course, with a district judge hearing such cases, who undergoes much more rigorous training and must have a law qualification as a prerequisite. The stakes in cases such as this could not be higher. This singular, most important decision, if misjudged, can set in motion a truly devastating series of events, thereby irreversibly damaging a child and their life chances. Compare and contrast for a moment, Madam Deputy Speaker, the role of magistrates in the criminal courts. The maximum sentence magistrates can hand down is 12 months. Sentences beyond this are remitted to the Crown Court to be heard by a circuit judge. In comparison, a decision about a child's domestic arrangements until adulthood are frequently made by individuals with no specialist knowledge or training in family law. Furthermore, in the absence of formal legal training, subconscious bias amongst magistrates is likely to run higher than amongst members of the judiciary. We can also take note of the approach taken by other courts in England and Wales, Madam Deputy Speaker. Specialist judges preside over employment, immigration, business and property, and social entitlement cases. Even in cases where a panel of 3 hears the case, it is a legally qualified specialist judge who sits in the chair. Given the importance of such decisions to a child's long-term prospects, Madam Deputy Speaker, the historic and outdated practice of magistrates hearing private law children's cases should, in my humble opinion, be abolished. It is an inefficient and unreliable system of dispensing justice in the modern world. It runs the risk of reaching inconsistent decisions of varying and questionable quality. Far too often, one hears of cases simply being decided as a timetabling exercise, a child's weekly diary being carved up without proper thought or consideration of the impact on that child. Removing the role of magistrates in private law family cases and ensuring that all such cases were heard by a specialist family judge would ensure greater consistency of decision-making, applying a more judicious and impartial approach. On this most consequential of issues, we should be ensuring that those who preside over them are not only appropriately legally trained, but also well versed in the emotional, psychological and social factors in play. There should be a much greater consideration and focus on ensuring that the decision makers are trained in childhood development, domestic abuse dynamics and trauma-informed practices. The system in England and Wales is almost virtually unique in permitting lay magistrates to determine such matters, with most jurisdictions across the world entrusting the decision to a suitably qualified judge. Of course, in more complex cases, Madam Deputy Speaker, consideration of specialist panels, as deployed in other tribunals, should be considered. And such panels could be constituted with a judge as chair, along with suitably qualified wing members, which may include expertise in child psychology, for example. By adopting this model, Madam Deputy Speaker, the panel can take a more holistic approach to decision-making. So my ask of the Minister is a very simple one. If as a society we aim to create a better future for our children, if we truly believe in progress and not merely maintaining the status quo, if we are to be believed when we talk of improving life chances for generations to come. Then will the Minister commit to reforming this outdated and harmful system and ensure all child arrangement cases are appropriately considered by a qualified judge? Thank you, Madam Deputy Speaker.
Minister, Sir Nicholas Dakin.
Thank you, Madam Deputy Speaker. Can I start by congratulating the Honourable Member for Solihull and West Shirley on securing this important debate this evening, and also applaud the very thoughtful and considered way that he's approached a very challenging area. I think we would all agree that the disruption and pain caused to children when these things are happening is something that all of us would want to do everything to mitigate. And I also think that he's very correct in saying that we would all want to have the anchor point in everything we do, the child's best interest. So I applaud the way he's set out his concerns. It's well known that family breakdowns are almost always challenging, disputes at times unavoidable and often intense, with children caught in the middle. The family court plays a crucial role resolving these disputes. Before I begin, I'd like to clarify that magistrates who sit in the family court are formally referred to as lay justices. However, for the purposes of today's debate, I will use the term family magistrates as it is more widely recognised. The Honourable Member is well aware that the family justice system in England and Wales relies on the work that family magistrates do to ensure the most vulnerable members of society, particularly children, are protected and their best interests are prioritised. And I welcome the words he said about the importance of magistrates in our justice system, even though he has concerns about the role they play in this particular area. Although family magistrates do not have formal legal qualifications, they undergo a rigorous selection, Madam Deputy Chair, and a comprehensive training process provided by the Judicial College. And it's worth noting that family magistrates have been involved in family proceedings long before the inception of the family court in 2014. Before this, family magistrates in the civil and county courts would sit on family proceedings and make decisions about arrangements for children. So there's a long history in our law of this. Family magistrates are recruited from the community and bring a diverse range of impartial perspectives and experiences to the court. This diversity helps to ensure that decisions are fair. It's crucial that we recognise and preserve their contribution to the family justice system for several compelling reasons, especially in the light of the arguments made by the Honourable Gentleman in both his recent article and the debate this evening. So he's suggesting that family magistrates should no longer be able to make child arrangement orders. The House will know that these are family court orders which detail arrangements for a child, including where the child will live and how they will spend time with each parent. And the Honourable Member has spelt out some of the implications of that very clearly. The Government appreciates the concerns raised by the Honourable Member regarding the training of magistrates. However, we believe the existing system has safeguards in place, which I would like to outline to offer reassurance not only to the Honourable Member but to all others listening into this debate. I'm talking here about the training magistrates receive, the role of the Justice's legal advisor and the robust protocols the family court has to allocate and reallocate cases. I can assure the Honourable Member that the quality of training provided to magistrates is of a high standard. To safeguard their independence from government, the statutory responsibility for training family magistrates rests with the Lady Chief Justice, as set out in the Constitutional Reform Act 2005. These responsibilities are exercised through the Judicial College, which offers a comprehensive training programme to equip family magistrates with the necessary skills and knowledge to handle the intricacies of private law children's cases effectively. This training ensures that family magistrates are prepared to make informed decisions that prioritise the welfare of the children involved. Further information on the college's training programme can be found on the Judiciary's website. When sitting in the family court, Family magistrates are supported by the Justice's legal advisers, who are qualified to provide advice on the law and procedures family magistrates must follow, and who are also subject to an ongoing family training requirement. All judges, including family magistrates who hear applications for child arrangement orders, are obligated by the Children Act 1989 to have the child's welfare as their paramount consideration and must undergo extensive training. To be appointed as a family magistrate, each individual must undertake training on determining the best interests of the child, navigating the welfare checklist, and ways of communicating with people in court, particularly where there is high conflict. So let me further emphasise and underline the role of the Justice's legal advisers in assisting family magistrates in these cases. A panel of family magistrates decide cases with the presence and involvement of the Justice's legal adviser. Recent case law, Derbyshire County Council versus Marsden, confirms that these advisers play, and I quote, Madam Deputy Speaker, an integral and legally required part of the decision-making process. Justice's legal advisers provide essential guidance and support to family magistrates, ensuring that decisions are made with a thorough understanding of the complexities of family law and always prioritising the best interests of the children involved. Nor are family magistrates operating in a vacuum. They rely on assessments carried out by trained professionals for arrangements orders, prohibited steps orders, and other key rulings when making arrangements for children. This collaborative approach enhances the quality of the family court's decision in these very sensitive cases. Family magistrates do not deal with the most complex cases in the family court. Established rules and guidance determine the appropriate level of judiciary based on a number of factors, including the complexity of the case. Cases involving certain complexities will be immediately allocated to other tiers of the judiciary, to district judges, circuit judges, and at the most serious level, High Court judges, in accordance with the issued guidance. So it's like a series of lifts. They are entering at the appropriate level. The judiciary, including family magistrates, have an ongoing duty to keep allocation decisions under review, particularly if further information is received from the parties and CAFCAS. The case can then be reallocated to a more appropriate level of judge, depending on the complexity and issues in the case. This can happen in the course of proceedings. This system ensures that magistrates handle appropriate cases for which they are trained, while more complex cases are managed at a different level of the judiciary depending on the issues in the case. This mechanism not only maintains the efficiency of the legal process, but also ensures that justice is served appropriately. Family magistrates also play an essential role in the effective functioning of our family justice system. The number of outstanding cases in the system has grown since 2018, and the average time taken for cases reached a high of 47 weeks in 2023 under the previous government, which is similar to the data the Honourable Member shared earlier. Whilst we have taken steps to address the underlying issues, which means we are on track to reduce the outstanding caseload by more than 10%, there are still significant challenges facing the system. Family magistrates routinely deal with a number of cases about children. Removing that capacity from the system, Madam Deputy Speaker, would fundamentally undermine the effective administration of justice. But more than that, the resultant delays in resolving cases would have a profound impact on the well-being of the children involved and for parents seeking to resolve their issues. Furthermore, the government remains committed to reforming private family law processes where appropriate. Just last week, the government announced that our new Pathfinder model of private family law proceedings will be extended to mid and West Wales in March and West Yorkshire in June. It is a significant reimagining of private law proceedings, with dedicated support for domestic abuse survivors, upfront multi-agency information sharing, and a greater emphasis on the voice of the child through the production of a child impact report. These proceedings allow our judges, including family magistrates, to have a much richer understanding of a family's circumstances from the outset and ensure parties are fully supported by professionals. Madam Deputy Speaker, to conclude, it is clear that family magistrates are indispensable in hearing private law children's cases. Their collaboration with Justice's legal advisers, the quality of their training, the mechanisms for allocating and reallocating difficult cases, and their contribution in alleviating the burden on all our judges are all critical factors contributing to a more efficient and effective legal system. By maintaining the involvement of family magistrates in these cases, we can ensure that the best interests of our children, which is what we're all focused on, are upheld, and that justice is delivered in a timely and compassionate manner.
The question is that this House do now adjourn. As many as are of that opinion say aye. Aye. The ayes have it. Order, order.